forward, we're taking this right into the current world that we live in of digital content creation. The ADCF outlines for us a number of focus areas around digital content. And one of those focus areas is digital capabilities 3.3. That's digital copyright and licenses. So, this particular focus area is about understanding how copyright, subscriptions, and licenses apply to data, information, and digital content. And I'm sure that's something that you are all a part of creating in your own RTOs in some way, shape, or form, be it your learning resources or your course content, the extra little things that you do to help your students in creating LLM support resources. There's all sorts of times when we may need to bring in extra content to support what we've already got. The focus area 3 outlines the intermediate level of this as being able to identify the rules and best practice around copyright and the licenses that routinely protect this digital information. So you should really be aware of the differences and the different forms of usage rights that there are between the public domain, Creative Commons, and copyright and licensing. To help us explore this today, I would like to introduce Liesl, the Senior Manager of Education Licensing at Copyright Australia. Thanks so much for joining us, Liesl.
Thank you, Jasmine, for having me. It's great to be part of the community today for this important session.
Excellent. We've got a few things to cover off, just so everyone has an initial understanding of copyright. Could you firstly explain for us exactly what is copyright and what is its purpose?
Yeah, absolutely, Jasmine. Well, copyright is effectively a form of intellectual property protection that exists under federal legislation. Now, obviously, we're going to focus quite a bit on how it works in Australia, and it is important to know that there are different laws in different countries around the world. So most countries have their own copyright legislation, but obviously what we'll be talking about today is primarily how it operates in Australia and what the specific rules are here. But effectively in Australia, the copyright exists as a form of exclusive protection of rights for copyright owners and creators. And it basically permits those owners and creators to engage in certain activities exclusively. So that includes the right to copy, so make digital copies or physical copies of works, the right to communicate, which generally refers to sharing material electronically, such as via the internet or via email, etc. And also the exclusive rights to publicly perform a work. So whether that be music that's performed in a concert or even in a classroom, that's a public performance in some instances, as well as the rights to publish and adapt works. So those are exclusive rights that under copyright legislation are exclusively available to the owners and creators of those works, unless the owners and creators decide to grant permission to a third party to use those works in those ways, or unless the third party is relying on a specific exception under the Copyright Act, which we'll talk about perhaps in a little bit more detail later. In terms of what copyright protects in Australia, it is important to note that it protects expression rather than ideas or information. So as an example, if you're thinking about an oil painting, for example, a beautiful oil painting of a landscape, the copyright would protect the landscape itself and the way it's depicted, but it wouldn't necessarily protect the idea to paint the landscape, and it wouldn't protect the techniques used to do the painting. So any specific brush techniques that are used, for example. So it really is the expression that's protected rather than the ideas or the underlying information within a work. And I think the second piece of that question was what the purpose of copyright is. And there are a couple of purposes. One of the primary purposes is to provide an economic incentive to creators and copyright owners. So copyright enables a flow of remuneration to go from people that are using copyright in various settings through to owners and creators. And as you can imagine, I'm sure if we didn't have copyright, there'd be very little incentive for people to create new content if there was no way for them to receive remuneration effectively. So obviously creators can include everyone from authors to photographers to film directors, and obviously if they're getting paid, it then incentivizes them to create more works, which can then be enjoyed and then obviously used in an education context as well. So yeah, that's one piece of the purpose. And then another important piece as well of the purpose of copyright is that it actually provides some control to creators and copyright owners. So the same thing, if you were an artist and you created an artwork, it's nice to know that you've got some control over how that artwork's going to be used, and you've got some say in how it's going to be used, importantly as well. So it's about providing control to those owners and creators to ensure that they can manage a little bit of how their work is going to be exploited.
Thank you. Excellent. That makes things a lot clearer and was a really great explanation. And thank you for including the explanation of the painting, because that analogy really helped me to make sense of it. So
Mm.
when we're talking about digital content, what does that actually include?
Yeah, absolutely. So digital content includes anything that can be made available digitally. So anything you can find on the internet will generally be digital content. So that includes examples of text content, so documents, ebooks, articles.
Yeah.
Text that's on a website, that they're all examples of digital content. And then images, so anything that you can find in a Google image search is an example of digital content there. So artworks, photos, diagrams, cartoons, anything visual that you can effectively find online. It can also include audio. So thinking about podcasts, sound recordings, such as like musical sound recordings, and also radio broadcast that's made available digitally as well. That obviously falls within the audio bucket. And then lastly, a really big piece is video content. And that's very relevant to the vet sector, of course, because video is a really great way to learn as well. So video content, which is included under digital content, basically can include any video that's found online. So if you think of both short form and long form content, and both user generated content, such as videos found on YouTube, on Instagram, on TikTok, they're all examples of short form digital content, but also long form digital content as well, provided by official digital platforms such as Netflix, and for example, the television broadcasters in Australia, they've all got their own digital channels as well, where they make a lot of their programs available. So all of that falls within the bucket of digital content. And the other important piece as well to mention in relation to that is that nowadays, digital content doesn't just include pre-existing content that you can find online. Now, as of a couple of years ago, there's that really big piece, which is generative AI content. So I'm sure most of you are familiar with all of or some of the more popular generative AI platforms, such as ChatGPT and Microsoft Copilot. And there are also platforms that create images, such as Midjourney and Adobe Firefly. There are lots of them. They're popping up every day. But all of those platforms allow you to create your own works, basically, based on content that's previously been ingested into the generative AI platforms. So digital content includes those new works that are created by those platforms as well.
Excellent. That's a really interesting area, and I think we might start to explore that a little bit further as we get a bit deeper into it. Just to the question that everybody, I guess, is asking is, how do we avoid infringement and ensure that we're complying with the copyright legislations?
Yeah, absolutely. So look, the really important thing in the first instance is to understand what your context is. So what environment you're working in, and what specifically rules apply to your situation,
Mhm.
because there are different rules that will apply to what you're doing personally, to what you're doing in your workplace. And then obviously, even within different workplaces, there are different rules that apply. And I'll obviously put quite a focus on the vet sector talking about this, because that's what we're focused on today. But it is important to differentiate when you're in those different environments.
Mm.
It's effectively, if you want to avoid infringement, you need to be aware whenever you are potentially using a third-party work, whether it be any of those types of content that I mentioned before, whether it be documents, ebooks, audio recordings, visual art or images from the internet. It's really important to be aware of where you're sourcing it from, and potentially who owns the copyright, and whether there is a specific exception that applies to what you're doing. So the other important thing to be aware of as well, I mentioned before that copyright protects expression rather than information or underlying ideas. So another analogy there, because it can be difficult to get your head around, another analogy there is that copyright will protect a short story as it's expressed, but not the general ideas behind the storyline. So just because someone's written a story about star-crossed lovers doesn't mean that you can't write your own story about those same lovers, provided you've expressed it in a different way, for example. So yeah, I guess it's about looking at what the content is that you're wanting to use. Copyright limits how you use content in a education environment, depending on the types of blankets that your institution might have in place. So again, it's important to be aware of the landscape at your RTO. For example, there are blanket licenses available to all Australian RTOs that are administered by a couple of different organisations in Australia, one of them being my organisation, Copyright Agency. And then there's another organisation called Screenrights who have a licence that covers TV and radio broadcast. It is important to get across whether your RTO has that blanket in place, because that will limit what you can and can't do. For example, all Australian TAFEs have the licence in place with Copyright Agency. So that means that everyone working for a TAFE in their day-to-day job at a TAFE can comfortably use third-party text and images from digital sources within the context of their training, preparation and delivery, because they've got that license in place. In the private sector, it's a little more case by case, because there isn't a sector-wide agreement. So it's about looking at your individual RTO and assessing whether you have an agreement in place. And if you do, then great. And you can look at, I guess, what the limitations are there. But if you don't, then you need to be even more careful and cautious, and make sure that the rest of your staff are careful and cautious as well. Now, in the instances where you don't have a blanket license in place, or you can't rely on an exception, and we'll talk about exceptions a little bit later perhaps, you might be in a situation where you need to obtain clearance on a case-by-case basis. So you might find, hey, I want to use this great article that I've found online within the resources that I'm providing to my students as part of a unit of study. And if you, as I say, if you don't have permission or a blanket license, you might need to actually get permission. So whether it's yourself or someone else who's in charge of managing that internally, there's a process that you usually need to go through where you track down the copyright owner, whoever that might be. If it's for example, if it's a newspaper article, it'll be the newspaper publisher that you want to use. Or in the case of videos, it might be whoever's uploaded the content, if it's a user-generated content video. And then you basically need to agree on terms with that person or that organisation before you can get the permission, the licence from them, basically, to use that particular work. So yeah, it's really, as I say, broadly, avoiding infringement is about being aware of your specific scenario and how it applies to what you're doing day to day, and then ensuring that you are seeking approvals where you need to, so that you're avoiding any possible implications for the RTO and for yourself individually as well. And in terms of what those implications can be, there's a range of things that can happen if you infringe copyright, but obviously one of the routes is that the copyright owner can potentially pursue you for infringement. There are a few different things that can happen. So it is good to ensure that you are crossing your T's and dotting your I's with regards to that.
Yeah, no one wants that to happen, of course.
That's right.
And I'm sure that for our vet practitioners from the TAFE communities, you'll be a little bit relieved to hear that information. But I know that we have a lot of practitioners in our vet community that do work for private RTOs. So that is going to be really important for them in particular to learn more about this. Uh, so that we understand initially, what's the duration of copyright protection? So, if I find an image that's really old, is it still under copyright?
That's a really good question, Jasmine. And again, what the information that I'm providing to you is based on Australia because it does change from country to country.
Yep.
And with regards to copyright duration, it does depend. In fact, I will direct you, I can share the link with you later if you'd like, Jasmine. There's a really great information sheet on the Australian Copyright Council website that breaks down all of the durations for different kinds of works because it does change. As a rule of thumb, for text and image content, it's the life of the creator plus 70 years.
Okay.
So it's longer than some people think.
Mm.
And as I say, there have been some changes to it over the past 50 odd years.
Yep.
But yeah, so generally keep that in your mind as I suppose a rule of thumb. But I guess my advice around considering whether a work is in the public domain is really to be careful with it because it's not as simple as just that life of the creator plus 70 years. Like sometimes it requires some more investigation. So you do really need to treat that with care when you are looking into it. Once copyright does expire, then a work will go into the public domain. Which effectively means that there's no remuneration that's payable for the use of that work anymore. So you can use it. But as I say, you do need to really investigate it before you can be comfortable that a work's public domain. And often you'll probably need, you may even need some legal advice on it.
Yeah, and of course, this session today does not represent legal advice in any way. So
That's
we
exactly right.
just like to stress that to our audience. So you're mentioning public domain, and we've
Yes.
heard also the term Creative Commons there
Yes.
in the ADCF. So what's the difference between these forms of usage rights like public domain and Creative Commons?
Yeah, excellent. So, as I mentioned, public domain is the term that we use when a work is no longer protected by copyright. So it is a term that's used for a few different things. Sometimes people aren't really sure about it when they use it, but that's the actual official meaning of it. It means that a work's no longer protected by copyright. So what that means is that there's those exclusive rights that I mentioned before, such as the right to copy, the right to communicate, etc. They're no longer exclusive rights. So, for example, if you took, I'll take Shakespeare as an example because that's clearly in the public domain. If you took a play by William Shakespeare, which is clearly in the public domain, you could do what you want with it if it's an original version of it. So you could publish your own copy of it. You could communicate it, copy it, perform it in public, and you wouldn't need to get permission or to pay a fee for the use of that work. That's the overarching freedom, I suppose, that you have once a work is in the public domain.
Yeah.
With that said, there are a few very important things to be aware of. And I did mention before that you really do need to look into works thoroughly before you decide that they're public domain. There isn't a register of public domain works. So it's not as simple as going into a website and typing the name of a work in to ascertain whether they're in the public domain. That might change, but at the moment, there's no complete register of it. So it means that you need to, you or your organization need to conduct your own investigations to be confident that it is in the public domain. The other thing to be aware of as well is that whilst an original work such as this Shakespeare play from 500 years ago may be in the public domain, a more recent translation of that work might not be. So
Interesting.
if you've got, as I mentioned Shakespeare, which is in English, but if you have like a French poem from 500 years ago, but that's recently been translated, whilst the original poem might be in the public domain, the translation might very well be protected by copyright. So
Okay.
be aware of that. And then the other thing as well is that the works might have been republished with new works in them. So if we're, again, referring to the analogy of a Shakespeare play, if it's Romeo and Juliet, if a publisher has published that play recently, within the last 50 years or so, it may be that it contains images that are protected by copyright, or notes that are protected by copyright. And it may even be that published edition, which is basically referring to the formatting of the book and the typeface. It might even be that is protected by copyright. So it's not, even though the original work might be in public domain, unfortunately it's not as straightforward as that all the time, and you really need to look into it. But yes, once it is completely in the public domain, you do have that freedom to use it without without infringing copyright and without needing to make any additional payments. So that's public domain.
Yeah.
The other piece that you mentioned was Creative Commons, and that's a really important one to discuss. I feel that a lot of people in the vet sector are aware of Creative Commons in some way, but they may not be completely sure of what it is. So it is important to be across that. So basically, Creative Commons is a license structure which exists whereby the owners of a work, and I'll use text works as an example, but it can apply to anything. The owner has decided that they're comfortable for their works to be used in certain environments without receiving a payment. So
Okay.
effectively, by using a Creative Commons license, they're basically granting a permission to people to use their works in certain usage scenarios without needing to obtain permission or to pay a fee for that use. So in an education setting, and obviously that's what we're talking about today, Creative Commons licenses always allow for educational purposes. So if you're wanting to use a work that has got a Creative Commons license attached to it, and you'll know that because it will be attributed at the bottom of the work. There'll be some wording to say that it's protected under a Creative Commons license. Then in an educational setting, so within the context of a class that you're delivering or preparing for, you are allowed to use that work. It doesn't necessarily extend to other types of more commercial exploitations, but within an education context, Creative Commons works are permitted to be used. Now, what I would recommend is that if you want to learn more about Creative Commons works, there are databases available online. So if you actually, there's a Creative Commons official website, which includes lots of information about Creative Commons, but also includes databases of content that you can use. And you do need to use a little bit of judgment, just because there is a possibility that there's not necessarily someone vetting all the works that are uploaded. So there might be text and image works there. So if you see a Mickey Mouse, it's probably not going to be a legitimate Creative Commons work. But the idea is that anything with that attribution attached to it is available under a Creative Commons license.
Excellent. Thank you for that really clear explanation of the definitions between those two, and particularly how we would know, because I think that was the next thing that came straight into my mind was, how do I know the difference between the
Yeah.
two? That's really great. Thank you. And just to everybody, we can pop the links to that further information that Liesel's mentioned in the chat at the end. And we'll also include that when we do publish the session on our website as well. So if you are looking for that further information that's being mentioned, we will share it with you. I have noticed a couple of questions popping up there in the chat. If you could please just hold your questions until the end, and we'll be more than happy to explore them then. So can we just talk, Liesl, a little bit about the common exceptions under copyright? What sort of exceptions do we have, like the Fair Use Act or Section 28? What do these mean?
Yeah, absolutely. So, obviously, there are lots of exceptions under the Copyright Act. They all apply to very specific situations, but a couple that are more relevant to education are Section 28, and then and fair dealing as well. So, yes, let's, I suppose, talk about those in a little bit more detail. You're not expected to know every single exception in the Act. That's for a copyright lawyer, but it is good to be across a couple of the more key ones.
Yeah.
So fair use is a really interesting one. And in fact, I have people all the time contacting me wanting to talk about fair use. The interesting thing about fair use is that fair use doesn't apply in Australia. So it's a really common question that comes up, but fair use is actually taken from US legislation. So it applies to organizations based in the US. Obviously, people hear that word, they read up about it online, and then they think that we have it here in Australia, but we don't. What we do have in Australia is something called fair dealing. And there are some similarities, but it operates in a bit of a different way to fair use in the US. So fair dealing is basically a very it's an exception under the Copyright Act that allows for organizations and people to use works in certain situations without infringing copyright. And I'll talk you through what those are. There's one in particular that relates to education, and then the rest are a little bit less relevant. But basically, fair dealing will allow you to use works for the purposes of research or study. So that's the one that relates to education. Now, importantly, I'll drill into that one a little bit before I touch on the others. Importantly, research or study, the exception under the Act to use a work under the fair dealing for research or study, it doesn't actually apply to the educational institutions staff.
Yeah.
So what it applies to is to students and their activity. So as a teacher, as someone who's delivering education, you can't rely on the fair dealing exception for research or study, but your students can. So what that means is that if you've tasked a student with completing an assignment, under that exception, they are allowed to copy and communicate excerpts of works as part of their completion of that assignment. And there'll be no infringement if they do so. They're legally allowed to, and there's no cost to them for that. So that's the exception that applies to them. But as I say, educational institutions, vet practitioners can't rely on it. So,
And can I just clarify, sorry to interrupt, that if
yeah,
a student is, using work in their assignments, and they haven't attributed that work to the author, is that then going to make a difference?
yeah, absolutely. Well, sorry, yes. So that would be an issue too. So that
Mm,
that falls under the moral rights obligations of the Copyright Act, which is a different section. But yeah, so students and staff, everyone has an obligation under the moral rights requirements of the Copyright Act to credit a creator unless it's reasonable not to.
yeah.
So that means that whenever a student is using and as you mentioned, an excerpt of a third party work in an assignment or something that they're producing for class. And also, anytime a teacher or someone that's working in an administrative capacity for an RTO, for example, if they're using a third party work, even if they've got permission, they still need to credit the creator. So there's still a requirement there. Now, with that said, the requirement under the Act is just to credit the creator. You and your provider may require that they're providing a more thorough analysis of where they're obtaining their information from. And that might be for academic purposes or whatever. But under the Copyright Act, the only requirement is that you're crediting the creator. So it can be as simple as just writing the name of someone who's created the material. Now, there are instances where you may not have that information. And particularly when you're working with digital content, it can be a challenge.
Yeah.
if you're, for example, if you found an image on the internet, and often images are kind of shared everywhere and it's not really, no one's really sure where they came from. So in instances like that, it could be pretty reasonable to say, I don't really know who the creator is. But the rule of thumb is if you've got the information, you should be including it in some way.
Excellent. Thanks for clarifying that.
Yeah. So yeah, that's fair dealing for the purpose of criticism, sorry, of research or study.
Mhm.
The other areas of fair dealing apply to certain other limited scenarios, including criticism or review. So, for example, if you're writing a review of an album and you want to kind of include some lyrics in that review, then that would be allowable under that exception. Parody or satire. So
Yep.
that's less in the education space. But if you want to make a YouTube video parodying another YouTube video, that would fall under that exception. Reporting the news and the enabling a person with a disability to access material. So that's one that can apply in the vet sector.
Very
So
nice.
again, if you have a work that's only available in small print, but you actually have a visually impaired student who requires it in a larger print, for example, under the Copyright Act, you're not infringing copyright if you enlarge that work. So you're making a copy and enlarging it to provide to
Mhm.
that student. So that's important to be aware of as well.
Absolutely. Yeah.
Yeah, so that's the fair dealing. Now, Section 28, I'll just touch on briefly as well, because that is important and relevant to what you do. And Section 28 is basically a small section of the Act, of the Copyright Act, that allows for the public performance of works.
Mhm.
And when I'm saying works, it could be anything that we mentioned before. So text, images, audio, video, etc., in educational institutions. So it's specific to education
Yep.
for educational purposes. However, it only applies to institutions that operate on a not-for-profit basis. So it's very specific. So
Mm.
what that means is if you work for an RTO that operates on a not-for-profit basis, and TAFEs fall within that category, private RTOs may not. It depends, obviously. Then you are permitted to play videos that you found on the internet, to show images within the context of a classroom without getting specific permission. So it's a bit of a funny one, but again, that's
Mm.
where it's about being across the landscape of your RTO. What kind of RTO do I work for? Are they a not-for-profit? Are they for-profit? Because that will impact whether you can rely on that particular exception day to day.
Excellent. And we do have a few not-for-profit RTOs that I know are a part of our community. So I'm sure
Mm,
that they would have found that helpful if they weren't already aware of it. Thank you.
yes. Mm.
So in a vet setting, what type of licenses or exceptions are available to legally use videos and images and text when we're delivering?
Yeah, excellent question. So obviously, Section 28 that I mentioned in specific situations. The other big one is the statutory education licenses that I
Mhm.
touched on just before. So I'll give you a really brief overview of them just because they're really particularly relevant to the education sector. But basically, they're licenses that are available to all Australian educational institutions, and they sit within the Copyright Act. So they're not a license that a private company has granted. They're actually a mandated license that all RTOs in Australia can apply to access. And as I mentioned before, all Australian TAFEs have the text and image statutory education license in place already. And basically the licenses, there are two statutory education licenses, one for text and image, which we administer, and the other one is for TV and radio broadcast, and that's administered by Screenwrites, another organisation. And both of those licenses allow RTOs to copy and communicate third-party text and images or TV and radio broadcast in the case of Screenwrites for educational purposes without seeking additional permissions. So they provide a blanket carte blanche, effectively, to take content from third-party text, image, or TV and radio broadcast sources, and to use those within the context of a class,
Mhm.
or in preparation for the delivery of a class. Now, those licenses, as I say, they do need to be actively put in place for your RTO. So they're not automatic. But if you work for an RTO that has one in place, then you can take text and image from any source in the world, and use it within the context of your classes. Generally, the licenses, with obviously this isn't a session just on those licenses because we can talk about them for a very long time. But generally, those licenses won't, the text and image license won't allow you to copy books in their entirety.
Mhm.
Generally. So generally, they just allow you to take a portion that's reasonable. So that's where you're allowed to copy the 10% or one chapter if you have that license in place. But it is unlimited in terms of the different places that you can get that content from. So it covers all digital content, that is text and image content, that you can find on the internet, as well as from physical sources as well. So yeah, that's a really key one to be across, just because it is so broad, and it
Mm.
is available to all educational institutions in Australia. There's also an organisation called APRA AMCOS, who you might have heard of,
Yeah.
um, and they look after music rights. So they represent writers, like songwriters, effectively, and they actually have blanket licenses that are available to all kinds of educational institutions as well that cover music. So it's a little bit fragmented in that you need to deal with a couple of different organisations for these
Mm.
different licenses. But yeah, APRA AMCOS are the music people, effectively. And then apart from those blankets, so those blankets, as I mentioned, are very broad and overarching.
Mhm.
There are lots of other options in terms of putting in place direct licenses and agreements with rights holders. So again, you'll need to look at your individual RTO as to what you've got set up currently. If you have a library, then your library team will probably be able to tell you what subscriptions you have available or licenses. And if you don't, there might be someone else internally that manages that. But yeah, there are lots of RTOs will have a mix of, they might have a license with copyright agency or screen rights. They might also have a suite of direct licenses as well.
Mhm.
So there are journal databases, obviously, that you can subscribe to, online newspaper subscriptions, stock image subscriptions as well. So got companies like Getty Images and Shutterstock. They're all subscription-based agreements,
Mhm.
that many companies have kind of got in place in some way. And then obviously for the vet sector, there are your purchased vet resources as well, which a lot of
Yeah.
RTOs have as well. So in the vet sector, it's usually a mix of those things, and it really depends on the provider as to which of those they have in place.
Yeah, it really is quite a complex field. And so we're very appreciative of you joining us today and explaining it, because there's just so many nuances behind each scenario and type of content, isn't it?
Absolutely.
Yeah. So for RTOs and those that are responsible more so for the management of this within their RTOs, what is the best practice relating to the management of copyright compliance, do you think?
Yeah, absolutely. And again, it will depend on the type of RTO that you have. And the bigger ones, obviously, in the TAFE sector, all of the TAFEs have got dedicated copyright people, which is fantastic.
Hmm.
Obviously, in a smaller RTO, you may not have the capability to have someone that's just looking after copyright. But it is really good practice, and it is really great it's a great idea from a best practice perspective to have the responsibility sitting with someone, just because it is such a complex area. And that person can become the expert as much as they need to be, and advise other people internally, because it's true that it is a complex area, and there are changes to
Mm.
the legislation and all kinds of different things, particularly with all of this uh, generative AI content that's turned up in the last couple of years. So it can really be helpful for one particular person to be appointed as the copyright champion internally, if you don't already have one, and that can ensure that you are all staying on the same page, and that there is I guess a communication plan around any changes, or any necessary training for staff as well. The RTOs that I've seen that operate the best tend to have particularly at that mid to larger size, tend to have a roster of training sessions as part of their internal professional development as well, where they'll run a session every couple of years, just so that anyone that's new in the team can get across the way they operate, and and any licenses and things that they might have in place. So yeah, that's certainly really important. I mentioned before being across the copyright landscape of your institution, and that's just the most critical thing, because it's incorrect to think that by changing RTOs you're going into the same environment, because even within TAFEs, if it depends, obviously. Probably, I would imagine if you're within the same state, working for the same TAFE, that there'll be similar rules. But if you're changing states, things can change quite significantly in terms of the permissions and licenses that are in place. So yeah, it's making sure that you're, I guess, across the landscape of your individual institution, and the other really important thing is to ensure that wherever possible, you're using your official digital teaching environments to make content available to students. For example, most RTOs are using pretty great learning management systems nowadays. And that's a really great way to provide content to students, because it permits you to manage who's accessing the content. And it also permits you to take content down after it's no longer relevant, or once the students have moved on to other courses, etc. So yeah, so look, we strongly recommend that. Whilst in some circumstances you can share material via other channels, it's just a really good practice to make it available via a gated learning management system, just to ensure that you are managing who has access to it. There are also some learning management systems and other technology tools that have inbuilt copyright compliance workflows. So that's something that you can be across as well. And it's just about looking across the environment as to the different technology options that you have available. If you are in a position where you are able to make recommendations internally, it is good to consider that when you are considering technology options, whether there are copyright compliance workflows, because that can certainly just take one less it can reduce risk and take one less stress off your plate if you know that you've got a system that's helping you to manage when you're using content and whether you have the appropriate permissions. So that's certainly something to consider. And then, as we mentioned before, Jasmine, crediting creators of copyright protected material is sounds pretty obvious, but people do forget sometimes. So it's important to ensure that staff are aware of that requirement to credit creators unless it's reasonable not to.
Excellent. I think that gives a really good perspective on that broader side of compliance, that really has to be integrated into the policies and processes and planning of an RTO, doesn't it?
That's right.
From the frontline perspective, that's really helpful from the management perspective. But when a teacher's just sitting there trying to gather together some resources before a class, how do you think we're best to develop best practice for actually that initial developing and integrating and modifying of digital content?
Yeah, so and the modifying is an important point, which I can talk about as well. Look, I think the first thing to be aware of when you are looking for content online, obviously you want to make sure that you're providing really relevant, rich resources to your students, but equally it's important that you're using reputable sources.
Yes.
And that's a really important piece. So if you have an option, say you're looking at using a chapter from an ebook and it's available on, a legitimate publisher website versus Pirate Bay, it's better to get it obviously from the legitimate publisher source rather than from a website that looks a little bit less legitimate. So that's a really obvious way that you can limit your risk for yourselves as as vet practitioners.
Mhm.
And then you mentioned modifying works as well, Jasmine. And
Yeah.
again, that does come back to the area of moral rights that we were talking about a little while ago. So, under moral rights obligations under the Copyright Act, there is that requirement to credit creators, but there's also a requirement that you're also not modifying works in a way that could potentially be considered to be derogatory to the owner.
Mm.
So that's actually a moral right. That's not something that can be removed. So basically, I guess I'll give a little bit of an example there. If you can imagine a situation where you've got an artwork that's been created by a Ukrainian artist, and then someone takes the artwork and sticks a Russian flag on it. Right? Those countries are not in the best place at the moment. You can imagine that's a pretty obvious situation where you think, okay, I suppose that artist might be offended by that. They might find that to be
Mm.
derogatory to their work. Unfortunately, it's not always as straightforward as that, because people can find things to be derogatory that we might not anticipate.
Yeah.
And we don't always know what the individual situations are. But I guess it's about treating third-party works with sensitivity, and anticipating things that might be deemed to be offensive to a
Yeah.
creator. And yeah, it is grey. There's no rule book on what you can and can't do. If you're unsure, you can get legal advice, and
Mhm.
that's a really good option as well. There are a couple of places where you can get free legal advice on matters like that, but they are, just due to their nature, they are quite grey. So yeah, it's just about treading carefully with third-party works. You are permitted to modify them, but just being aware of what you're doing to the work and whether it might cause offense to someone.
Yeah. So if
Mm.
I wanted to take a picture and change the color scale to match my organizational color style guide that we have, is it okay to take someone else's image and totally change the color scheme of it, but still use that image?
I'd say it's unlikely to be offensive if you're just changing the color, unless the colors carried a particular cultural meaning or something.
Mhm.
But with that said, just taking an image, you still need to be aware, like you still need to be asking, do I have permission to take this image?
Yeah.
So again, does my RTO have a license in place that allows this? Or am I relying on Creative Commons or another exception? Like how am I allowed to do this? And then you make the decision around, can I change the color scheme?
Yeah.
It doesn't seem to be offensive. I'm comfortable that I can do this and it's not going to cause any issues. And obviously make sure that you're still crediting the original creator as well. So
Yeah.
even if you've changed the color, you'll still put the original creator, and you may put a little note to mention that you've altered it. That could be good practice as well. It's not a requirement, but it could be it could be a good way to operate.
Great. I think that's a really good quick summary of the workflow there. That first question to ask ourselves is really, do I have the right to use this image before we consider anything else,
Yes.
and working through it from there. Excellent. We have had a few questions popping up throughout the session. I haven't really been taking them to note, but I've noticed a few questions in there. So we will open up for a quick Q&A now. And then after this, if our audience wants further information, where can they find out more about copyright?
Yeah, that's a really good question. So there are a few different sources. It is important when you're looking up information on copyright that you are looking at websites that relate to Australian copyright law, because as I mentioned, there are differences. So if you're looking at a US website, it's not going to apply to what you do here. Some great websites or organisations in Australia include, our website at Copyright Agency. So that's copyright.com.au, pretty straightforward. So we have lots of information on copyright on our website. Our website mainly deals with text and images. So because that's the area that we look after as an organisation. So just be aware of that. But there is a lot of great content there. The other organisation that I would recommend that provides a more holistic view of copyright in relation to all kinds of works is the Australian Copyright Council. So they're a not-for-profit organisation in Australia as well, and their part of their remit is to provide information and resources on copyright in Australia as it applies to all different kinds of organisations. So they've got lots of free worksheets that specifically relate to educational institutions like RTOs. And they also have workbooks that you can buy. They're pretty inexpensive, digital and physical workbooks that you can buy that really
Right.
deep dive into some of the legal questions that you might have. And the other service that the Australian Copyright Council provide is a free legal advice service.
Mm.
So I mentioned that before. We don't provide legal advice in this session, but if you do have a specific legal question that relates to whether you can do something in your specific situation, you can actually write to the Australian Copyright Council, and they have a team of copyright lawyers who'll respond within a couple of weeks with a view on what you should do in your particular situation or what's available to you. So if you go to their website, copyright.org.au, you can access all of that information and then also the legal advice service for free as well. And the last resource that I would recommend as well, and this is specific to TAFEs. So if you work for a TAFE, the Department of Education has actually set up a website for you just on copyright because there's so much to deal with. So it does only apply to TAFEs and schools as well, but it's called Smart Copying. So it's smartcopying.edu.au. And as I mentioned, everything on that website is authored by the Department of Education. And it is really in depth as well and very specific to how TAFEs operate. The other piece on that website that's really helpful is they've included a list of copyright contacts at TAFE. Again, because it's such a specific area, it's got its own website. So if you do work for a TAFE and you have a specific copyright query, the recommendation from the department is actually that you talk to your copyright contact. So you go to the Smart Copying website, you track down the contact for your state, and that is the person who is whose remit is solely to provide advice internally at TAFE on copyright matters. So that's probably the best place to start for TAFE practitioners.
Wonderful. And some really good sources of if you are going to be the designated person to work with copyright compliance in your organization. I think all of those sources, maybe if you're not with the TAFE one, but they're all really great sources and really good to know that that legal advice is there and free as well, because a lot of people would hesitate to seek that, perhaps, worrying about fees and that sort of thing. So it's really great to know that we can be free in asking the questions that we need to know the answers to, and that there is really good sources of information and guidance in that area. I have
Absolutely.
seen a couple of good questions come through, so
Sure.
just scroll back up and read out some of these questions. So one of the first questions here, we might rephrase a little bit. The question is, what sort of evidence would we need to provide to ASQA? But I think it's the second part of this question, and other regulatory audits that we are complying. So how does somebody who's going to audit us to know that we're complying or not?
Yeah, so ASQA, the way that ASQA bundle copyright into their general audit, so they include it as part of, I guess, everything that they're looking at, because it falls under their requirements to comply with other relevant legislation, and copyright legislation is one of those pieces of legislation that they're, I guess, checking up on as well. So the easiest way to show to ASQA that you're complying is to show either that you've got the relevant third-party blankets in place, if necessary, for what you're doing, and maybe provide a copy of the agreements that you have with any third parties. So, for example, if you have digital licenses or subscriptions, it would be good to include those in whatever you're submitting to ASQA as well, because that will obviously verify that the content that you're using within your course delivery is covered off from a permissions perspective. The other thing that we provide as well to RTOs who have an agreement in place with us, a copyright agency, is we've got a good copyright governance logo, which you can actually include on your website or anywhere on your materials, which actually enable you to advertise to ASQA and obviously to the public if you wish as well, that effectively that you're complying with copyright by having the statutory education license in place.
Right.
So that's an option as well. We also, and I think Screenwrites do as well, we also publish lists of RTOs who have the blanket licenses in place on our website. And ASQA are aware of that, and they actually use those lists and refer to those lists as well. So that way they don't have to ask us to check on, whether certain RTOs are licensed or whatever. So yeah, that information is all publicly available. And then, as I mentioned, all TAFEs are covered under blanket agreements. So it's more for the private providers that fall outside of the TAFE sector that we have those lists published. Does that help?
Absolutely. So in summary, I think as long as you've got that license in place and you include that information with your submission under an audit, then that's clearly justifying your position and using those resources. We've got a couple more questions here. I think we've got time for maybe one or two more. We've got a question. Can I legally pick another RTO's learning resource and use it for training at my RTO without modifying, without permission, assuming that I have the required licenses? So can someone
Yeah,
come in and grab our resources? We're going to publish this for everyone shortly and then use it in their RTO.
that's an excellent question. And there are a couple of considerations there. So you mentioned, or the question mentioned, if you have the relevant blanket licenses in place. So if you work for an RTO that has the statutory education license in place for text and images, you are permitted to use text and image excerpts from any source in the world. And that does include content that another RTO might have created. Because the license is actually mandatory, not for educational institutions, but for the content creators. So you can't actually opt out of it as a content creator. So yes, theoretically, you could use content from another provider. With that said, you would need to look at the specific situation with regards to how you obtained that content. So for example, like how did you obtain those resources? If you obtain those resources because you signed up as a student at another RTO, you probably need to look at any terms and conditions that you agreed to when you signed up as a student at that RTO, for example, or how that material was provided to you. Like if you obtained it while you were working for that RTO, again, you'd need to look at the terms of your employment contract and potentially consider whether you're breaching the terms of your employment contract by taking that content to another RTO. So theoretically, yes, you would be able to use excerpts of that content, but in practice, you would need to consider a few other elements as well.
I particularly picked up on the word excerpts of that content there. So can I just clarify for our audience, can they use the entirety of the content? 100%?
Yeah, good question, Jasmine. So, and again, we didn't dig into the statutory education license in a huge amount of detail today because it requires its own session. But the license generally won't permit you to copy works in their entirety for educational purposes. It generally only allows you to take excerpts. Now, the rule of thumb for excerpts from third-party works under the statutory education license is 10% or one chapter. So that's generally what it will allow you to do. So if you've got a resource that a third-party RTO has published or made available, and you want to take an excerpt of that, theoretically, the 10% or one chapter yardstick under the license is the amount that would be allowable. And obviously with the caveat being you need to consider all those other things that I mentioned, other terms and conditions and contracts that you might have.
Excellent. Thank you very much. That is all of the questions that we have time for.